Alison Siegler, thank you so much for joining me on Office Hours.
Hi, Tamara. I'm really happy to be here.
So you led this epic defense litigation that involved 43 defendants across 12 cases who were charged in these so-called fake stash house sting operations that were carried out by the ATF. And you alleged that the ATF engaged in racial discrimination and violated their rights under the Equal Protection Clause of the Constitution. So we have a lot to discuss here, but I do want to start with the basics. What are these fake stash house sting operations and how do they generally work?
So in these fake stash house cases, what happens is that you have a federal law enforcement agency that literally creates a crime and then chooses people to commit that crime. Okay, so like sometimes it's the FBI or the DEA. Often it's a federal law enforcement agency known as the ATF, the Bureau of Alcohol, Tobacco, Firearms, and Explosives. And like the way these cases start is typically an informant who's working for the ATF will go up to a guy on the street who's down on his luck and will say, hey, I know of this stash house. Okay, it's filled with drugs. You want to go and rob this thing with me. And if we do this, you will make like $500,000, okay, for just one day's work. And then if the targeted person agrees to participate, which often people do because it's such a like incredible opportunity and, you know, sort of pot of gold at the end of the rainbow for a lot of people who are poor and struggling, then an ATF agent, a law enforcement officer will get involved and will say to this person, you know, okay, so this stash house is going to be swarming with guards. So you need to bring your friends, you need to bring your guns, you need to have all your friends bring guns. And they kind of amp this up. All right. And in the end, like this whole thing turns out to be completely made up. All right. Like there's no stash house. There are no drugs. There are no guards. The whole thing's like a total fiction. Nothing exists. But the ATF gets like this whole thing on tape. Okay. And then federal prosecutors step in and they bring not fictitious, very real federal drug, gun, and robbery charges against the people who've been targeted by the ATF. And all of this is like for attempting to rob a fictional amount of drugs from a non-existent stash house. And then to make matters worse, and Tamara, this gets at the question you asked about race discrimination, overwhelmingly, the ATF goes after poor people of color in this scheme. Okay, so like they select people of color to commit these made up crimes. And there was like a nationwide study that showed 91% of the people they selected were people of color. And in our Chicago cases, it was 92% people of color.
So I definitely want to come back to the race component of this, but just to back things up a bit, what kinds of charges are brought in these cases and what kind of sentences do they carry?
So everybody who's caught up in this gets charged with 3 federal crimes: drug crimes, gun crimes, and robbery crimes. Okay. And this is like drug conspiracy for the non-existent drugs. And 2 of those crimes carry really high mandatory minimum penalties. So you've got this drug offense, this drug conspiracy, which carries a 10-year mandatory minimum. But if somebody has even one prior conviction for another drug case, they're looking at like a 15 or 20-year mandatory minimum just on that crime. Okay. And then the gun case that gets brought is a 5-year mandatory minimum. But for a lot of the time that they've been bringing these cases, if you were charged with a second gun, like a second gun was involved, you would get a 30-year minimum just for the guns, plus your 10 or 20 for the drugs. So you could be looking at 50 years minimum penalty. And when I say minimum, I mean 50 years in prison for this fabricated, constructed crime.
Looking at the historical backdrop, how did these sting operations get started? When did they get started?
So this all got started a while back in Miami, back soon on the heels of the war on drugs, which we all know now has been a failed war on drugs, right? And there was one ATF agent who was really spearheading this strategy and who was going all around the country teaching other ATF agents and offices about how to use this. But I think the reason federal prosecutors and the ATF like this strategy is that it's like shooting fish in a barrel, right? It's like really easy to get an arrest and a conviction for this kind of thing because you create the crime, you can get it all on tape, you can, there's some really disturbing ways in which they kind of amp up the crime, by saying, oh, lots of guards, make sure you have guns, make sure you have protection. And it's just, they can orchestrate it and then they can take people down. And I think they convince themselves, I know what they publicly say is, we're going after the worst of the worst, but that's absolutely not borne out in practice.
So how often is it that the ATF ends up arresting really dangerous, violent criminals and seizing lots of weapons, as opposed to arresting people with minor criminal records?
Yeah, I'll just give you an example from our Chicago cases on this question of, who are they actually going after in practice? Who are they getting in these stings? In our cases, the ATF said, we are targeting people with, we are targeting established robbery crews. We are targeting people with serious prior convictions. We are targeting people with access to guns. Okay. But in reality, the vast majority of the Black and Latinx individuals who they went after, who they swept up in this, they didn't meet those requirements, right? So many weren't currently criminally active. Many didn't have ready access to guns. They didn't meet the requirement of being an established robbery crew. In one of our cases, our clients could only find an ancient gun from the 1800s that they had to duct tape together. This is not, in another case, I got to tell you, I read about another case where the ATF literally provided the gun to the people that it had, swept up to commit this crime. So just taking this fabricated nature of the crime to a whole new level there.
So to a non-lawyer's ear, this definitely sounds like entrapment. Why wasn't the entrapment defense viable here?
So people do often feel like this sounds like entrapment. They're like, how is this even legal? How is this even possible? In fact, I'll tell you, Tamara, I've had people think I'm joking when I talk about these cases. They think I'm pulling their leg, okay? But in practice, this entrapment defense is virtually impossible, okay? It's virtually impossible to prove that at trial as a matter of law, because if the prosecution can show that someone was predisposed to commit a crime, then it's not entrapment. And they can use almost anything to show predisposition, right? Like drug addiction, prior criminal history, things like that. So almost everybody who's tried to fight these cases as entrapment has been convicted and gone to prison for decades.
So you end up representing 43 defendants across 12 cases. And this litigation had a lot of firsts or unique aspects about it. But one of the strategies that was unique was that you treated it almost as a class action. Now, in the criminal law context, there are no class actions. So how did this work procedurally, and how did you get away with it with the court?
Before my clinic even got involved, this group of lawyers in Chicago came up with a brilliant idea of attacking these cases as race discrimination, okay? Because they saw almost everybody the ATF was targeting and selecting to commit this made-up crime was Black or Latinx, right? And so I just want to sort of shout out to those lawyers. They included criminal defense attorney Stephen Saltzman, then federal public defender Candace Jackson-Akalumi, who's now a federal judge, and then a lot of her colleagues at the federal public defender's office. And that group of lawyers convinced a number of federal judges to do something really rare, which is to order prosecutors to turn over discovery, which just means information. And that discovery included internal ATF documents about how they construct these stings. And it included data about what the race of everybody in ever charged in a Chicago case was, okay? So really important information. This was a remarkable discovery victory. And then a couple months later, lawyers from that group reached out to my clinic and asked us to get involved. And we joined forces with them to develop really a vision for how do you convince federal judges in Chicago to actually dismiss these cases on race discrimination grounds. And I just have to say, I was fortunate to be working with this incredible team, okay? The original lawyers, my colleagues in the clinic, including Professor Judith Miller and Professor Erica Zunkel, both of whom are incredibly accomplished former federal public defenders, and many, many law students of ours contributed also, like monumentally over the years as we worked on these cases. But one thing, as you mentioned, that made our strategy unique, there were really, I'd say, two things, okay? So first, one thing was we decided, let's try to prove racially biased policing with statistics, right? Let's hire an expert and develop statistical evidence that wasn't available in like a lot of the prior cases that we read about. And then the second unique thing was what you mentioned, this collective or class action strategy. And as you said, there were 43 individual clients charged in 12 separate cases because they were charged in kind of groups. And they were all pending in federal court in Chicago, kind of pending trial, waiting to go to trial. And Judith and I became, and then Erica joined in with us, became pro bono co-counsel for like all these clients and decided like, let's go after this in this coordinated, programmatic way, which is really rare because usually in the world of criminal defense, you're talking like one client, one case, individual representation, right? And so, as you said, you know, there's not really a thing as a criminal class action, but I describe it like that because the idea was, let's get the judges to see that the ATF is engaged in a problematic practice that really spans a whole lot of cases and has swept up a lot of individual people.
In what other contexts do you think that the sort of criminal class action approach might work?
So that's a good question. I think pretty much any time that a lawyer believes that there's something racially discriminatory happening, especially that's been spearheaded, operations that have been spearheaded by the police or the law enforcement agencies, I think that there's a possibility of going after it in this kind of way. And in fact, during the time that our cases were pending, there was a very successful and somewhat similar litigation for a totally different kind of drug operation happening in San Francisco, where they also kind of coordinated across cases and brought a similar racial discrimination claim against the police and had some real success. So I think anytime you sort of, as a lawyer, you see things happening across a whole bunch of people in a similar kind of case, it's worth considering whether to do it in this coordinated way.
So let's move on to the legal standards. In order to prove racial discrimination, you have to show that the government engaged in selective enforcement. What's the legal standard for proving that? And why is it so hard?
I think I have to start all of this to talk about the legal standard here by going back to a 1996 case called Armstrong. United States versus Armstrong. And that case created like a virtually insurmountable standard for proving race discrimination by prosecutors in a criminal case. Okay. And what happened there was the defense presented evidence that 100% of the people charged in federal crack cocaine cases in LA were Black. Okay. They said everybody who is being charged is Black. And they said, this is race discrimination. We want discovery. We want information from the prosecution, like how are they selecting the people they're going after in these crack cases? And the Supreme Court said, no, you don't get that discovery. And they created this, what I call a catch-22, that then became this really hard standard for anybody to meet. Because what the Armstrong court said was to even get discovery to support your claim of race discrimination, you have to present evidence of race discrimination, right? The very thing you're asking for. And it just closed off almost all avenues to allege race discrimination by prosecutors. And then what happens is courts expanded Armstrong and they started applying it also to race discrimination claims by the police. And that's what when we say selective enforcement, we're talking about claims that the police discriminated and violated the Equal Protection Clause of the U.S. Constitution in selecting people to be arrested. Okay. But the problem is, you've got this information that you need to prove race discrimination. It's locked in a black box that you can't get access to.
Let me ask you, what was the Armstrong court's rationale for creating this almost impossible to meet standard?
It was very much based on the concept that we have to be really careful about asking questions about why prosecutors are charging cases in the way that they are, what their strategy is. Okay, that was basically the Armstrong court's concern, which does not apply to the police, right? And so, after Armstrong, part of like what we were facing when we began the Chicago litigation was that no court since Armstrong had ever dismissed a case either for race discrimination by prosecutors or for race discrimination by the police. And no court had ever even granted discovery information to the defense in support of that kind of race discrimination claim. So it was really a hard standard to meet at that point.
So Armstrong creates this sort of two-pronged test where you have to prove, one, that there was a discriminatory effect and that there was discriminatory intent. What kind of evidence are you presenting to prove these two prongs?
Yes. So there's this two-pronged test in Armstrong. You have to prove discriminatory effect and you have to prove discriminatory intent as the defense. Okay. And so discriminatory effect is a very, very high bar. The accused has to present evidence that similarly situated people were kind of available to be targeted by the prosecutors or police, but weren't actually, in fact, targeted. And when we say similarly situated people, we mean similarly situated people of other races, like similarly situated white people, for example, in this instance. And the defense in Armstrong lost because they just couldn't make that showing. And the way that courts have interpreted it, this similarly situated requirement is really hard to meet because, like, how do you find somebody who was not prosecuted, right? How do you find somebody who the ATF did not go after? How do you identify an individual person? Like there's no database of those people, right? And that's actually why we decided, okay, the best way to fight this is to try to get an expert to bring statistics out about that'll help us make that claim and that'll help us meet that standard of discriminatory effect. And then as far as discriminatory intent goes, it's also really hard. It's the idea that the policing agency kind of intentionally chose somebody, not in spite of their race, but because of their race.
Yeah. So how do you impute a discriminatory intent to an organization like the ATF or a police department when there is no smoking gun evidence that would prove that there was clear discrimination?
The way we decided to meet it was to say, let's get statistics. Let's have our expert. We hired an expert, Professor Jeffrey Fagan from Columbia Law School, to do this statistical analysis and try to show, okay, let's look at the 94 people charged in Chicago in every stash house case we could find after 2006. It was 94 people. And the racial composition, as I said, is 92% people of color. And let's compare that to the racial composition of what's known as a similarly situated benchmark group, okay, which is people out there in the world available to be targeted by the ATF, people who met the ATF selection criteria, but were not, in fact, chosen by the ATF to commit this fake crime, right? And so he said, if you look at the selected group of people in Chicago who the ATF actually went after, those 94 people, that group is 79% Black, okay? If you look at this comparative population of people who also had prior convictions for guns, drugs, and violence out there in the same universe, the same geographical area around the same time period, that group of people is actually just 55% Black. And, Professor Fagan, using statistical analyses, said there's an approximately 0% likelihood that you're going to get this really high number of Black people just by chance, like, which suggests that there's actually something else afoot, selectivity afoot, right, by the ATF. And he also then did regression analyses. I'm not going to get into the details of that, but he basically said, let's rule out any race neutral explanation for this really stark disparity that we're finding. And he said, I cannot find any reason that justifies or explains this racial disparity. It's the only thing left is race. And that's how he came to the conclusion that, he came to that conclusion, and we said, this is evidence of discriminatory effect. This is also evidence of discriminatory intent. But there were some other things, if I may tell you, Tamara, about the discriminatory intent, some like really interesting things that we were able to bring forward from the evidence. So, for example, we included this really cool chart that said, okay, the ATF has all of these internal criteria for how they select people for these to commit these crimes. But let's look at whether they're following those criteria, like whether they're actually doing what they say. It's kind of something we talked about earlier. And it turns out we were able to show that when they were going after people of color, they absolutely were not following their criteria. But in the few cases where they actually targeted white individuals for these stings, they were following their criteria very closely. And that, under another Supreme Court case, we argued was clear evidence of discriminatory intent, like intentional discrimination. And then there was one other thing, which is in some of our cases, the ATF actually had this like racialized script that they would use. So like, basically they would send an agent into the field, someone who either was or appeared to be Mexican, and the agent would make a point of explaining or alluding to the fact of his own race, and then would say to a Black individual, don't bring me people who look like me, okay? Suggesting I want people who look like you, meaning I want you to bring me other Black individuals. And like, that is incredibly problematic. And to us, that was clear evidence of discriminatory intent.
So the government hired their own expert witness and made a bunch of counter arguments, among them that the 290,000 people that were part of the comparison group in Fagan's report were, quote, absurdly broad, that it should have been confined to people who actually were arrested for home invasions. They also argued that he didn't control for various factors like employment and level of education. They also argued that the geographic location was too wide, that this effort was part of a search to stem an uptick in violence, and that local officials had asked for federal assistance. In a hearing, you said, quote, if you torture the data long enough, it will confess to anything. That's what the government's done here. What did you mean by that? And do you think the government was engaging in bad faith arguments?
It's not bad faith. No. What I meant by that is, what I meant by saying if you torture the data enough, it will confess to anything is, look, everybody knows that statistics and data can say a lot of things. And some people will say, it will say whatever you want it to say, really. And so the government's expert really tried to poke holes in Professor Fagan's report. And as you said, they said, well, his benchmark group isn't the right comparison. They're not similarly situated enough to meet the Armstrong discriminatory effect standard, all of that. But like, it was very frustrating because the way I see it, Professor Fagan's statistics clearly met the legal standard. And, if you go through this like multi-year Herculean effort to get discovery, to get data, and try to meet a standard that is just really pretty much impossible to meet, like there should be a recognition that I guess what I feel like, Tamara, is that by us actually trying to meet the standard, we ended up raising the bar for ourselves, or the government and the judges, one of the judges raised the bar for us and said, okay, you finally come closer than anybody else has ever come to meeting the standard. Let's just move it up a little bit and make it even harder. Like, that's the way it felt when we were litigating this. And, one of the judges actually ultimately said that he agreed with the government's expert. And he said, your evidence, the defense evidence, is insufficient. And I just think that was wrong I just think either it's wrong or it shows that the Armstrong standard is totally unmeetable, or both, because it just underscores the idea that it's pretty much impossible to prove race discrimination, even if you have the resources and the time to mount the kind of gold standard defense that our team mounted.
So I want to come back to the Armstrong standard. There are sort of two phases where it comes up, right? It comes up at the discovery phase and it comes up at the merits phase. But one thing you did was to distinguish the case at hand from Armstrong in arguing that law enforcement agencies like ATF, FBI, or on the local level police, there should be a lower standard of proof for these selective enforcement cases for them, because the nature of their jobs is different from that of prosecutors. Can you explain that distinction?
Yeah. So I think, to me, this is one of the biggest victories of our collective litigation here. Our Stash House litigation in Chicago was that we actually changed the law on this issue. Okay. We made it a lot easier for the defense to get discovery, meaning information, that would support a claim of race discrimination by the police specifically, okay, separate and apart from prosecutors. And yeah, what we did was, our clinic collaborated with the Federal Public Defender's Office and their chief of appeals over there. And we litigated a Stash House case all the way to the Court of Appeals called the Seventh Circuit in Chicago, that covers Illinois, Indiana, Wisconsin, all those states. And we convinced the Seventh Circuit to draw this distinction between prosecutors, which the Armstrong case deals with, and police, which our cases were dealing with, the ATF, the law enforcement folks. And the Seventh Circuit agreed with us, and they said, look, that impossible to meet Armstrong standard really shouldn't apply when you're trying to get evidence about race discrimination by the police, because it's just different. The police are different. There's not the same deference that is paid to prosecutorial decisions. In fact, we often question policing decisions, as we've seen in this country. We don't hold them. We don't put them on such a pedestal as prosecutorial decisions. And since then, a couple of other federal courts of appeals have also gone along and agreed with the Seventh Circuit and even taken this distinction farther. So now you've got 3 courts of appeals that have basically said they've gotten rid of the really high Armstrong hurdle to getting discovery about race discrimination by the police. Now you can get discovery basically simply by saying, I am aware that there's a group of people who have been targeted by law enforcement, and that group has a really high percentage of people of color. And that alone is pretty much enough to get discovery, which that was exactly the evidence that the Armstrong defense brought forward. And that was what the Supreme Court said is not enough in Armstrong. So it's a really big and important change. And I want to say, Tamara, this change is now leading to an even more important distinction between police and prosecutors. So it's changing the standard for actually just like proving discrimination on the merits at the end of the day, getting a case dismissed for race discrimination. The Seventh Circuit Court of Appeals just recently became the very first court in the country to say it's different for police. If you're trying to get your case dismissed because the police discriminated on the basis of race, it's a much lower standard. You just have to prove discrimination by a preponderance of the evidence. Very different. Okay, 51% basically, which frankly, looking back, if that is the standard that the judge had held us to, I think we would have met it. He held us to that clear and convincing evidence standard. I think our evidence, even with all of the things the government experts said, would have met that lower standard.
So I want to get to this hearing that took place in December 2017, and it's been described as unprecedented. What made it so extraordinary?
So the thing that was so unusual about that 2017 hearing in our cases is that we were able to convince all of the judges. So to take a step back, as you mentioned and we talked about earlier, there were 43 individual people charged in these cases, and that they were charged across 12 separate cases. Well, those cases were presided over by different judges, right? And there were actually 9 different judges because a couple of judges had 2 cases. But those 9 judges could have each had, every judge could have had their own individual hearing on the experts, on the evidence, on the motion to dismiss, because we were filing motions to dismiss across all these cases. But instead, we said to the judges, look, it's going to be a lot more efficient and a lot more practical to have the experts, and a lot less expensive, to have the experts testify just once, okay, in one hearing that is in front of all the judges sitting together. And it was amazing because the judges eventually, they cleared their schedules for several days to hold this joint hearing. And so if you could picture this, it's kind of like if you've ever seen those pictures of the Supreme Court, where it's, right, all those judges sitting up there on one high bench, presiding over a single court case. That's basically what it looked like physically. It was this big, huge, long bench in the ceremonial courtroom of our federal district court in Chicago with 9 judges sitting up there. All the evidence and all the witnesses were directed to all 9 judges. But the interesting thing is, because each judge had their own case, they were able to make their own individual decisions. Like, they were not in any way bound to decide things collectively. They were just hearing the evidence together. It was quite amazing. I mean, it was like having a jury made up entirely of federal lifetime appointment judges, you know, like, and that's basically what it was like. And that's what's so unprecedented. And that's, I don't think I've ever heard of that happening anywhere else in federal court in the country. Certainly it never happened before in our Chicago courthouse.
So these cases were ultimately resolved through plea deals. What did the plea bargaining process look like, and what were the sentences that the defendants you represented ultimately got?
It was really interesting because what happened after the hearing, so we did this big hearing with the experts, and the question then was, how are these cases going to be resolved? You know, are the judges going to dismiss the cases? Are the judges going to let the cases continue forward to trial and deny our motion? Are some judges going to do one thing and some judges do another? We really didn't know what was going to happen. And in the course of the post-hearing briefing and the weeks and months that followed this big hearing, the prosecutors came to us, the whole defense team, and said, we'd like to present you with you and your clients with some plea offers. And they said, this is basically a plea offer that applies to every single client, but no one is bound to anybody else. Each person gets to decide whether they want to take this deal or not on their own. It's not like some, blanket deal that has to either be taken by all or rejected by all. And the plea offers were extraordinary and really, really rare, because the prosecutor said, we will dismiss all of the mandatory minimums. All of the charges, mandatory minimums, meaning the drug conspiracy and the gun charges, which that alone on drug conspiracy and guns had most of our clients looking at either a 15-year minimum time in prison or 25 years minimum in prison. And if they were dismissing those, what was left was just a robbery, conspiracy to rob charge that would carry still some substantial time under the federal sentencing guidelines, like 4 to 10 years approximately, but no minimum that would tie the judge's hands, nothing that would prevent the judge from going lower than the guidelines would suggest. And so it was just really, and that was its own intense and interesting piece of the process, because then we, and also a lot of the other lawyers involved in the cases, had to sit down with our clients individually and speak with them. And this was something, Professor Zunkel and I spent a lot of time talking to a number of the clients that we were working with about, how do you make this decision? Because if you decide to take the plea deal, the prosecutors, the kicker was, then you have to walk away from the race discrimination motion. You have to say, I'm withdrawing my motion to dismiss. And I'm admitting to being involved, at least in the robbery, even though I'm not pleading guilty to the drugs or guns. But I'm admitting to all of it. And that was a really hard decision. It was a very individual decision that had to be made in communication with and consultation with the lawyers. And eventually, all 43 of our clients decided to take that plea deal, decided to plead guilty, because the risk of spending 15 to 25 years in a prison cell, in federal prison, far from their families, was just, I think, unthinkable.
You have written the quote, "The principle that underlies mandatory minimums is dehumanization." What was the legislative thinking behind mandatory minimums and sort of taking away a judge's discretion to customize a sentence to an individual defendant's circumstances?
I think when you're talking about mandatory minimums and the question of how those came to be, I think there have been times in our country's history when the legislature has been very concerned that judges are not going to hammer people hard enough with prison time. And so they created these mandatory minimum penalties that would basically tie the judge's hands, prevent the judges from making individualized decisions, and force the judges to give really high sentences. And there are some cases, still to this day, where judges are forced to give a mandatory minimum of life in prison simply because the prosecutor chose to charge the case in that way. Okay. The prosecutor gets to select the mandatory minimum at the very outset of the case, the charging phase of the case. And so then when it comes in front of the judge at the time of sentencing, the judge can't do anything about that sentence. They can't say, but wait a second, the thing that was motivating this crime was not greed, for example, it was desperation. There's all sorts of ways in which you would want a judge to be able to take into account the particular circumstances or this mandatory minimum has been charged by a prosecutor, case comes in front of the judge, and the judge wants to say, but wait a second, this guy isn't a high up leader of this. He's just a small bit player in some bigger conspiracy. He shouldn't be looking at the same sentence as the leaders. But the point of these mandatory minimums is hands are tied. And when I say they're dehumanizing, what I mean is it just takes away any ability to consider somebody as a human being. And I also really think, there's all this evidence of the racial disparities that are created by mandatory minimum penalties. And I'm very, to my mind, I'm convinced that no one would tolerate these kinds of just of really high penalties without any discretion for the judge if they were mostly being used against white people. I really think that part of why our society tolerates this is that the people who are serving really high sentences for mandatory minimums are almost exclusively people of color. And it's a terrible travesty. And frankly, it's something that President Biden, his Attorney General, Merrick Garland, they've both said, oh, we have to get rid of mandatory minimums, but they're not really putting their money where their mouth is, AG Garland is still letting his federal prosecutors all over the country bring mandatory minimum charges and asking judges to impose those high sentences. So it's a real problem. It's an ongoing problem.
How do prosecutors use these mandatory minimums as a tool when they're plea bargaining or negotiating a cooperation agreement?
These mandatory minimums, if somebody's charged with a mandatory minimum, the prosecutor has the ability to bargain it away, just as happened in our Stash House cases, right? So in our Stash House cases, the bargain was, we'll dismiss the mandatory minimum if you get rid, you withdraw your motion to dismiss for race discrimination. Okay, that was the bargain there. But the more common bargain that happens in a lot of cases is they say, look, if you cooperate against somebody else, somebody higher up than you, then we will give you a break below the mandatory minimum. And there's various, statutory and guideline mechanisms for doing that. But there's this idea of getting people using the mandatory minimum as a hammer to get people to cooperate against other people and to then make it easier for the prosecution to convict more and more people. And this is, this results in, part of the problem is you end up with people pleading guilty and admitting to things sometimes just to avoid that mandatory minimum. And that's another one of the many problems of mandatory minimums.
As we wrap up here, I want to zoom out on stings in general. So putting aside the stash house stings, sting operations in general, are they necessary for law enforcement, for public safety? And what is their legal footing?
I mean, to me, like sting operations that involve creating or inciting people to commit crimes, they're not necessary for public safety. Like, why don't the police and prosecutors just go after people who are actually committing crimes, like in a state of nature? Why make something up and target people to commit this crime? I really think like so much of our legal system, our criminal legal system, is built on this outsized fear, right? It's fear of poor people. It's fear of people of color. I think, again, no one is going after white people with these kinds of stings, certainly not in the same, to the same degree and in the same, mass way as it's happening even with the stash house cases. And as you say, sting operations go far beyond the stash house cases.
Are there any limitations on sting operations? For example, on the length of the operation, or at least having some sort of minimum required evidence to show criminality? We talk about these policies and laws, and we may lose sight of the fact that there are real people behind these cases. So I do want to highlight the stories of one of your defendants named David Cousins. Can you tell us about him and what made him vulnerable to accept this offer from the ATF? And then tell us what's he up to today?
When my students and I first met David, he had been locked up on this federal ATF stash house case for like 2.5 years. Okay. He'd been in jail waiting for his case to go to trial. And I think it's really hard for us to conceptualize what that looks like. He had spent 841 days in jail. Okay. Pre-trial, before being convicted of anything, presumed innocent, right? So David and his wife, they had 6 kids. Before he was targeted by the ATF, he was a very devoted stay-at-home dad. His wife worked downtown in Chicago, and he was at home with the children, who were all fairly young. But the ATF, they did this thing that they do. They offered him $500,000 for 1 day's work. He took this offer in a kind of misguided and desperate desire to be able to provide for his family. They had fallen on some hard times financially. Money was tight. And all of a sudden he finds himself facing this. Actually, David was facing one of the really high ones, the 25-year minimum sentence in prison. Okay. And so then imagine this, after David is ripped away from his family, it was a real struggle for them not to have him there, right? He wasn't there to feed the kids breakfast in the morning, to get them to school, to put them to bed at night. He wasn't there to change their diapers, help them with their homework. I mean, it was really hard on the family. And I think sometimes we forget, what is it like from the human side of having somebody locked up in a jail cell? David's wife, she really couldn't make it financially without him there, because she then was having to get childcare. And so ultimately, the family was rendered homeless. They ended up going kind of door to door, sleeping on the floors of relatives and family and friends, and just depending on the kindness of others in order to just have a roof over their heads while he was locked up. His kids struggled emotionally. I mean, they were just used to having their dad there for everything. And it was all really hard. And ultimately, my clinic, we got involved in his case. And one of my students and I actually did the bail hearing, where we were able to argue to the judge, hey, judge, we're pretrial here. Please release David and let him go back to his family while he's waiting for his case to go to trial, while he's waiting for this motion to dismiss to come to fruition. And, it was amazing. The judge released David. After he got out of jail, David was a total model citizen. Okay. By the way, this is somebody who had never before spent time, he'd never before spent time behind bars. Like, this was his first experience. So he did everything right. He became, he went back to being the devoted dad that he'd always been. He even became a Medivan driver where he would help people with their wheelchairs, help get them to doctor's appointments. So, there's this amazing photo of David at his son's 8th grade graduation, which happened like really soon after we got him released from jail. And he would never have been able to go if he had stayed locked up pre-trial on this case. When his case went to sentencing, by that point, it was after the hearing. I had another team of students working on the case, and we were able to convince the judge to do something that happened in a lot of cases, which is we were able to convince the judge to give David what's known as time served, meaning he got credit for the 2.5 years he had spent in jail, but he was not sentenced to another single day behind bars. So instead of getting 25 years, he was able to stay out, stay with his family, stay in his community, and continue to be, the really upstanding guy that he was.
Why do you do this work? What drives you?
I've spent my whole career trying to help people who are caught up in the criminal legal system, trying to represent people and advocate on their behalf, because I personally feel that no one there are very few people in this world who really need to be behind bars and who really need to be taken away from their families and communities in order to keep other people safe. I'm not saying nobody, but I'm saying there are very few people. And I think we as a society have such a fear-based way, and also a very racially disparate way of approaching crime, of approaching poverty, all of those things. And it's outrageous to me. It's upsetting to me. It troubles me deeply.
Well, thank you so much for doing this work. Alison Siegler, thank you for joining me on Office Hours.
Thanks, Tamara.